Hi, Ross Pitcoff here, and I wanted to briefly discuss with everybody what to do about the dispute resolution clauses that are contained in your operating agreement for an LLC, your shareholder agreement for a corporation, or your partnership agreement if you're just acting as partners. Very briefly, typically you'll always want a dispute resolution clause in any of those agreements. So if you don't have one, the default is that you can litigate matters in court. However, when you're looking to figure out dispute resolution clauses and what they should look like, there are a few things you want to take into consideration. Number one is you'll always want to make sure that you have in writing which jurisdiction's laws will govern. So if you're a New York company with New York parties that conducts business in the state of New York, you're going to want to state that the laws of the state of New York shall govern. However, if you're a corporation that's registered in the state of Delaware and you have employees in New York, but perhaps the business principal's address is outside of the state of New York, or even if it is in New York, there may be reasons that you'd want to see the laws of the state of Delaware to apply. Moving beyond that, you'll also want to create a jurisdictional location, a venue for claims. So if you're a business operating in New York City, you certainly would be likely to state that any disputes that arise shall be brought in the state of New York, and you'll even mention in the county of New York if you're a New York City business. The third layer of this, after figuring out the choice of law and figuring out the forum, meaning the location of where any matter will take place, is do we want to go to litigation in state or federal court, or would we consider arbitration, which is really an alternative means of resolving a dispute? Now, the benefits of going to litigation are that you can file publicly, which you may want to do, so therefore press can see what's going on, things will be made public, and in the event that you wind up going to trial to try to resolve a claim, and if you receive an unfavorable outcome, you can go ahead and you can appeal that decision to the appellate division. On the other hand, or the circuit courts if you're in federal court, the negatives of going to litigation is that it's considered to be costly. It takes a lot of time, especially if you're in state court. Cases can really drag out, and everything's in the public view. So your name, your company's name, and anything that happens, any allegations made can be made public. And for all you know, it could wind up in a Google search, or it could be found in a background check, or it could be picked up by media. So could be a benefit for you if that's what you want, but otherwise you also have to be careful because it could mean negative press for you and or your business. Now, if you choose arbitration, arbitration is a binding mechanism whereby a seat of typically 1 to 3 arbitrators will hear your case, both parties' cases, and make a determination. It's conducted a lot like litigation, but it's typically streamlined in terms of length, and a determination can be made far more quickly than what you might see in court. Arbitration still is expensive. It might be a little bit less expensive than litigation, but it really depends on how everything's set up. For example, if you have 1 arbitrator versus 3 arbitrators, because essentially you're paying for that arbitrator hourly. So the benefit is you keep things out of the public eye. Everything is able to remain confidential. However, the detriments are that if you receive a determination that you don't like, it's very difficult to appeal. So you lose that process of going to the appellate division or going to the circuit courts to argue that the laws weren't properly applied to the case. Now, does that mean that it's impossible? It's not impossible, but you really have to show an extreme prejudice by an arbitrator against you as the party in order to be able to justify seeking to uphold or append, a determination rendered by an arbitrator. There's a third mechanism for dispute resolution, one that's not binding, and that's mediation. So typically what I see, and what I think is fairly often a good idea, is that a lot of dispute resolution clauses will contain a mandatory mediation provision to say, in the event the parties are not able to resolve their dispute, they will go to mandatory mediation. That's where you have a mediator listen to both arguments from both sides, and then they try and go ahead and resolve the claims between the parties. So you spend a day or two with the mediator, both sides go to separate rooms after making their initial arguments, and the mediator works with you to see if you can reach a reasonable resolution. In a business transaction dealing with a breakup, that can be pretty complex. So 9 times out of 10, I'd say, or maybe it's 8 or 7 out of 10, but you can actually wind up saving the company and getting what you want, or at least getting a lot more of what you wanted, without having to go through a lengthy litigation or arbitration by doing mediation. Then what you do is in the same clause, if mediation isn't able to resolve the case, then you go ahead and consent to mandatory arbitration. I think that's a bit of a safer route because it does keep you out of the public eye, and you never know what's going to happen going down the road, but certainly an expedited arbitration, knowing that your name and your company are not going to be subject to public ridicule, is a pretty powerful tool to have in your repertoire, excuse me. So it's something to think about. Wanted to provide some details on that. Thank you.